The First Amendment's constitutional protection of free speech is a cherished American freedom. It's often one of the very first safeguards pointed to that separates the United States over even other representative republics. The right to speak frankly, even critically, on a matter without interference by the government has long been understood as uniquely American. But this is an area where free speech and the First Amendment are losing ground. Occupational speech. Every day, Americans are being told that their right to free speech isn't actually a right when they're talking for their job. And that's what's happening in one of IJ's latest cases. We're challenging the right for a group of paralegals to be able to give basic legal advice to willing customers, many of whom don't have other options. Advice which the government is trying to stop.
We can't fill out forms. We can't discuss statutes. We can't explain particular things because that's considered practice of law to some degree for North Carolina. And so because they've spelled it out very clearly, we don't do it in the lawsuit, will allow us to have an opportunity to have those discussions or to be able to provide those services without penalty.
That was SM Carnoodle-Hodges discussing the root of her lawsuit, which she has teamed up with IJ to take on. With us here today are IJ attorneys Paul Sherman and Christian Lansinger, who are advocating for her in fighting this case. Paul, Christian, thank you for joining us. We recently launched this case in North Carolina. Can you take us through who the clients are and what the case is about?
So we represent the North Carolina Justice for All Project, which is a nonprofit founded in 2020 to expand access to justice in North Carolina. And for the last 3 years, what they've been doing is trying to create some kind of limited right for paralegals to provide alternative legal services to lawyers. They've tried to get it done legislatively, and they have hit a brick wall in the state Senate. So with no other options, what they've decided to do is join with IJ to sue for their right to provide this advice, because fundamentally, legal advice is speech, and it's protected by the First Amendment.
And it's important to note that all 6 of these women are state-certified paralegals with decades of experience. All 6 of them have provided this same legal advice before, but under the supervision of an attorney. And 2 of these women in particular, Morag, Polaski, and Shawana Almendarez, want to provide this advice for free as part of the Justice for All project, but they also want to provide this advice for compensation at a rate that is much lower than the rates that are currently charged by attorneys.
So, guys, what makes IJ uniquely situated to take on this case?
IJ is the nation's leading legal advocate defending occupational speech. We've been doing it longer than anyone, and we've done it in a wider variety of cases than any other group. We've filed cases defending the right of people to give dietary advice, psychological advice, and we've also filed other cases, including one that's going on in New York right now, involving the right of non-lawyers to give legal advice. And fundamentally, what all of these cases recognize is that advice is speech protected by the First Amendment. And when occupational licensing laws burden that speech, the government has to demonstrate that there's a real problem and that it has regulated in as narrow a way as it possibly can. And we don't think it can do that here. We think that our clients can give this kind of advice safely and that it can be a tremendous benefit to North Carolinians who otherwise might not be able to afford a lawyer and whose only other option is to try and navigate these legal problems all on their own.
And so you mentioned obviously now that it's a First Amendment case. Most people, when they think about the First Amendment, they might not be thinking about how that applies to their everyday jobs and their work. So can you talk to us a little bit more about that and explain a little bit more about how free speech is beyond what people might typically think about?
Yeah. So, and this is something that has been a core component of IJ's First Amendment work since we were founded in 1991. Because you're right, a lot of people, when they think about the First Amendment, they do think about political protests, or they think about offensive speech or things like that. But there's nothing in the First Amendment, in the text of the First Amendment, that limits it to political speech. The First Amendment says Congress shall make no law abridging the freedom of speech. And one of the things that we've argued for over 30 years is that this means that, for example, commercial speech, commercial advertising, is entitled to the full protection of the First Amendment. And we have also pioneered the argument that occupational speech, speech that people earn their living through, is similarly entitled to the full protection of the First Amendment. And this was something that a lot of lower federal courts had rejected for many years before IJ started litigating in this area. And then finally, a few years ago, in a case called National Institute of Family and Life Advocates versus Becerra, the Supreme Court made clear that there is no exception to the First Amendment for occupational speech or professional speech, however you want to label it. That means that the First Amendment fully applies even if you're giving specialized advice on complicated topics, whether that's law, diet, medicine, or anything.
So in essence, you're saying advice is speech and all speech is protected.
That's exactly right.
With the limited exception that if the speech was fraudulent or it was perhaps inciting violence, there are limited exceptions that the Supreme Court has provided where speech isn't protected. But the Supreme Court has explicitly stated what those categories of speech are. These women would not be able to go out and pretend that they're lawyers and tell people they're lawyers, or tell them that they're experts in something that that they know themselves are not experts in. But when it comes to legal advice or advice about any kind of subject like someone's legal rights, just because that subject might be something that's important doesn't mean that it's any less protected.
Yeah, that's a critical point. So a person who falsely holds themselves out as being a lawyer when they're not a lawyer is engaged in fraud. And fraud is not protected by the First Amendment. And there are all sorts of other consumer protection laws that can apply to people who advertise services that they can't adequately provide. But when it comes to the actual advice itself, the principle is the same as it would be with a book. Anyone is allowed to write a book of legal advice, and there is no principle in First Amendment law that would draw a distinction between a book on legal advice and giving that legal advice to someone in a conversation.
It makes me feel underutilized. It makes me feel that I have the tools to help someone in a hardship, and I just simply cannot do it because I risk being prosecuted for it.
That was Shawana Almendarez, who is part of the suit. In it, she described the potential punishment she could face for simply trying to help people using her legal expertise. Which brings us to the next part of why this type of service should be allowed. It goes beyond a legal argument and into a practical argument about making people's lives better.
The missing middle is not the rich, it's not the poor, it's the in-between, it's the uncounted group that may not necessarily be in the LIM community that we discussed earlier, the low income and economically marginalized. We're seeing that families can make $125,000 a year and still not be able to pay for legal services or retain counsel and still need that same support.
So tell us a little bit more about this missing middle and what they're trying to address.
As Cornell mentioned, the missing middle is a group of moderate income individuals and families that might be able to afford some legal services, but not the extraordinarily high rates of licensed attorneys that might go as high as $500 an hour. What makes them unique is that not only can they not afford the high rates of licensed attorneys when they need legal help, but they also are ineligible for legal aid and some of the free legal services that are available to them. Because the income cap for these legal aid services are very low. It's generally just above the federal poverty level. So not only can these individuals not access paid services, they can't access free legal services, and they have no access to justice whatsoever.
That's definitely a barrier that we need to address, and I'm glad that there are individuals like them willing to fight and do it. So, Paul, this isn't IJ's first case going up against the unauthorized practice of law. Can you talk to us a little bit more about IJ's history here?
Yeah, so IJ has another case that's currently before the Second Circuit, U.S. Court of Appeals, which covers the state of New York. The case is called Upsolve v. James. And like this case, Upsolve involves non-lawyers who want to provide limited legal assistance to people facing common legal issues. In Upsolve, it's essentially bogus debt collection actions. There are companies that buy up debt and then they try to collect. And many people lose those cases not because the debt is meritorious, but because they simply don't know how to respond to these lawsuits and they can't afford a lawyer. So the court enters a default judgment against them, and then they're in a worse position, even if the debt would otherwise have been legally uncollectible. What Upsolve wants to do is have non-lawyers who are trained provide a certain limited amount of advice on how to respond to those lawsuits, essentially telling them how to fill out court-created forms. And that's exactly what our clients want to do in North Carolina. courts have responded to some of the most common legal problems by creating informational packets and court-created forms for dealing with things like evictions, domestic violence restraining orders, uncontested divorces. And lay people with no legal assistance fill those out all the time. But because they're lay people, they don't always know the pitfalls of filling out those forms. They can make mistakes, and even if they don't permanently prejudice their legal rights, they can end up delaying the resolution of their cases in ways that can cost them time and money. Just a little bit of simple advice from someone who's familiar with the forms can save them a tremendous amount of time. And there's no reason why they should have to pay someone who went to 3 years of law school to get that kind of advice.
Absolutely. And it sounds like some of those issues you mentioned are also so emotionally charged and close. They might need somebody to help them think clearly to make sure that they're getting what they need done properly.
That's exactly right. And this is something that our clients have stressed to us when we've talked to them specifically about civil no contact orders and domestic violence restraining orders. These are extremely vulnerable people who are upset. They may not have access to much monetary resources at all. Often they're in extremely controlling relationships, which is another barrier to their hiring a lawyer. And someone who is familiar with this process, who can walk them through the forms to make sure they check the right boxes, is really what they need so that they can get justice and, frankly, so that they can stay safe.
All they need is a little bit of help. And yet, when I try to give them that help, that's classified as the unauthorized practice of law.
Christian, we just heard a clip from Morag Black on why this is so vital, and not just for the people involved in the lawsuit, but for all North Carolinians. Is she right?
Morag's exactly right, and she gets to a fundamental issue with the way that the North Carolina law is designed right now. These forms are created by the courts so that people can fill them out themselves. It's only when they try to get help from someone who actually knows these forms, has seen them for decades, that suddenly it becomes a problem. And even when we know that a lot of this advice happens all of the time. This advice, we see this with bartenders, cab drivers, and in between family members, and it's not an issue. It's only when someone knows what they're talking about, like these women at JFAB, that suddenly they can't provide this advice.
So does this case have implications beyond just allowing legal advice? And would more people benefit from a potential ruling in our client's favor than just the specific industry and state?
Absolutely. So the precedent that we hope to set in this case, first of all, would be broadly applicable to these same kinds of unauthorized practice of law statutes across the country. But also, it raises fundamental questions about distinguishing between regulable professional conduct and speech that is protected by the First Amendment. And that issue arises in occupation after occupation. So it's not limited just to legal advice. It can be dietary advice, which is subject to licensure under dietetics laws. It can be relationship advice, which is subject to licensure under psychology or therapy laws. So the precedent that we set here definitely can be broadly applicable and speech protective.
So somewhat of an elephant in the room here, but you two are attorneys. And so maybe there are fellow attorneys who are opponents to this and say that this could be problematic to allow people to advocate when they don't have a law degree. Do they have a point?
Well, you know, it's funny because people often would needle us when we would take on occupational licensing laws, and they would say, oh, when are you coming after lawyers? And we would always tell them, they're on the list, just you wait. One of the things that we had to do was build up precedent defending occupational speech before we could bring this kind of case, before it was viable. But absolutely the same First Amendment principles apply. As for the predictions that this is going to have some major negative effect, I think they just don't hold up to any kind of scrutiny for a couple of reasons. Number one, the relief that we're looking for in this case is very narrow. There are a ton of things that lawyers do that everyone agrees only lawyers can do. Things like initiating litigation or appearing in court on someone's behalf. But this case is limited purely to providing legal advice. And as I mentioned earlier, anyone can write a book of this advice. So there's no reason why you shouldn't be able to give it one-on-one in person. The other reason is that there is precedent for allowing non-lawyers to provide this kind of advice, and it comes from our closest legal cousin, the country of England, because people may have heard of barristers and solicitors. What most people don't know is that there's actually only 6 activities that are regulated under the English unauthorized practice of law statutes. And those things are appearing in court, they are conducting litigation, things like conveying property, administering oaths, notarial activities. But anyone is allowed to give regular legal advice, and non-lawyers do give unlicensed legal advice in England, and there's no evidence that this has caused any significant problems. That's important because under the First Amendment, the government has to show that it has considered less restrictive alternatives, like the English system, and found that they would not work. And here, I don't think the state of North Carolina is going to be able to do that.
And it should be noted that for the people that want advice from someone like Morag and Shawana, the alternative is not hiring a lawyer. The alternative is that they get no advice and they go in by themselves. The Institute for Justice has lawyers and we represent people for free, but at the same time, there's not enough lawyers doing pro bono work or law firms like IJ to represent everyone who needs legal help. So it's important that we add people like Morag and Shawana who have decades of experience in areas like family law, a lot more than Paul or I do, to actually help people navigate these simple court-created forms.
Absolutely. If you wanted to fill out one of these forms in North Carolina, you don't want to be talking to me and you don't want to be talking to Christian. You want to be talking to Shawana and you want to be talking to Morag.
Gentlemen, thank you for walking us through this case today. Thanks to our courageous clients, and thank you to everyone who supports the Institute for Justice and who tuned in today.